Read the document and do what it says. There will be a fair amount of instructions. We try and give the trustees broad powers so that you can get things done without having to get any special permission from the probate court, but you've got to be aware of where the boundaries actually are. And you may have a favorite sibling. This is not the time for that to come out. We try and talk to you during the planning process, who is the best person to take these duties on? It's not always the oldest, it's not always the youngest, it's not always the one who's closest, but it's the person who you think can actually do what you're asking them to do and be fair about it. Tax requirements. We will talk to you. I don't want this to turn into a class on income tax, estate tax, etc. We will help you with that, but realize that there will be more than one tax return to be filed. And then segregate estate trust assets means if it's part of the revocable trust, you keep those assets in the name of the revocable trust. If it doesn't end up in your bank account without a significant amount of activity between those 2 points in time. Preserve and invest, you're going to want to make sure that you're not losing money, because the last thing you want is a beneficiary saying you did not do a good job managing my assets. This is where you'd also want to talk with some of the other advisors depending on what kind of asset you're talking about.
And depending on what kind of asset it is, that can be the same sort of property management type of deal issues as you would as a homeowner, as a car owner, particularly if you have a decedent that lives farther away from where the fiduciaries are. It can get a little tricky. You want to make sure the doors are locked, that valuables are secured, because, I mean, in theory, the beneficiaries could have a charge against the fiduciary if the fiduciary basically drops the ball and assets are lost because of their inattentiveness. So depending on the asset, it may require a little more in-person upkeep.
And that's why you would generally, in most of our documents, you would have the authority to hire helpers as well. You don't have to mow the lawn yourself. You don't have to list the house yourself. You have the authority to employ those to help you do what in the end is best for everybody. And then keep and render a full and accurate record and accounting. This is where we will be asking you, when you've gotten those assets gathered, and say you've got some probate assets and you've put them in an account and it's titled in the name of the estate, I want to see every deposit you've made. I want to see every check you've written out, because I'm going to have to tell the probate court about it.
And even if the probate court is not involved, which in many cases it's not going to be, you still want to be able to tell all the beneficiaries everything you did, because it's not your money. It's theirs. You just have an obligation to take care of it properly. And if you think about it that way and do what you would want someone else to do for you if they were handling your money, then that will help keep you on track.
And we hope that the trust administration side of it needs to not be anything the probate court worries about, but the probate court does have jurisdiction over disputes. So if in fact all of a sudden a beneficiary is going to bring some kind of a claim of some sort, now it very much is in their scope to deal with. So like everything you're doing, you want to be meticulous to sort of cover your tracks to make sure you have a demonstration. I did what I was supposed to do.
So again, taking possession of property, you want to make sure that everything is safe and accounted for. So anything, you'll have access to a safe deposit box if need be. It may be wise to open one in your own name in your title as trustee. Make sure that if there are firearms, that those are kept with somebody who can hold them in a safe manner. Changing locks on the house. It may be sitting empty for a little while. And are the assets invested appropriately? Again, this is where you'd want to work with trusted advisors as well to make sure that, maybe mom or dad really liked this one stock, and that was great for them. But at a certain point, as you watch it decline in value, it may be wiser and smarter to do something a little bit more economically prudent with it.
Yeah. And for instance, if dad is doing puts and calls on his portfolio and actively trading, you may want to just close all those positions out immediately. unless you're a sophisticated investor yourself, in which case you're probably perfectly comfortable making up the losses that you might incur to the rest of the beneficiaries out of your own pocket. Okay? That's why you want to be conservative.
So, Hank, logistics question.
Yeah.
So, where are trustees involved? So you have a trust in the will. So the dad died, dad set the trust up and such. Kid's a trust, child is trustee, adult child. Dad dies on Monday, funeral's on Saturday. So a number of expenses need to be, things need to be taken care of. Logistically, how does that work?
That's almost another whole seminar, Elvin, but basically you pay the bills. I do suggest that you don't put the charges on Dad's credit card. Yeah. Okay? Only bring that up because we had a case where that was done. Believe it or not, when the credit card company was told Dad died, they said, how do you charge that? But you do have to pay bills. With the trust, it's very easy because we're going to have, as the successor trustee, they're going to have access to the funds to write the checks from the trust assets. In the case of the estate, you don't have authority to do anything as executor until the court appoints you, as Rebecca pointed out earlier. Okay? So that's, and there's really not that much that honestly has to be paid that quickly.
And then we would make sure whoever, if somebody fronted it, there's a mechanism where they can be reimbursed relatively quickly.
And believe it or not, while the funeral director always asks to be paid immediately, if you say, we'll pay it out of the estate, they know they're the #1 claim against the estate. They know they'll get paid. The only time we've had getting them paid be a problem, was never out of the estate was it a problem, but they would, some funeral home directors are pushier about getting paid than others. And I think we've only had that be a problem once or twice, because we just say, hey, you're going to get taken care of out of the estate. You got a question about it, call our attorney. Okay, and there are other ways of dealing with that in advance. Yeah.
Okay. So again, for inventorying the assets, whether or not you're filing a formal inventory, do it. Will help you. You want to know everything that's out there. It'll help you keep track of what it is you're dealing with, and it'll help you to be able to explain any questions that any beneficiary might have. And it'll also help you do the math to figure out when you're funding sub-trust shares, what do you have, and how is it to be divided up? There's math involved. You need to know what you're starting with to get to a final answer. Eventually, you're going to be writing checks. And for probate, the probate court will review that inventory and will make sure that it pretty much balances. For small estates, there's a streamlined process. I'm sorry, go ahead.
Is there a minimum amount that, of your assets before it goes into probate? In other words,
no.
Required, so even if you have...
There's a minimum fee for $0 to $25, and it goes from there. So, are they really chasing a lot of people down who had $100 in a joint checking account and never actually told the probate court that so-and-so had passed away and filed their estate tax return? There's enforcement issues, but technically, no. If you pass away in Connecticut with $5 in your pocket, you should have some kind of contact with the probate court.
Like your furniture or something like that, or $2,000 car or something.
It all counts.
Well, there is a difference in the simplicity of the procedure we can go down. If the size of the probate assets is below a certain threshold, $40,000, and there's no real estate involved, you can go through what they term the small estate procedure, which there's still forms involved. However, there's less formal accounting, there's no formal accounting required on the back end, and the person who's presenting the information to the court is not actually appointed as an executor. They're just referred to as a petitioner, which means they're still entrusted to do a specific thing. They're specifically saying, I'm going to take this one asset I showed and get it to this person, and they bless that, as opposed to being entrusted. But as far as the probate court fee is involved, then there's no minimal size on that. Now, practically speaking, does everybody who has one $500 item, do they just hand it off to somebody? Probably. But under the rules, if you, particularly with the bank, They're not going to care how small it is. They're going to have to see something from the probate court before they'll let you do whatever it is you believe needs to be done with it.
Okay. Now, we're behind, way behind, way behind.
I can
What-
talk faster.
I-
You know I can.
Oh, yes, I've been victim to that. What I'm going to ask is, we want to answer all your questions, but we gave you a lot of paper to write on, and I think we even furnished pens. If you will please make note of your questions, I promise I'll stay until you get done asking questions. But otherwise, we're already going to be late, and we're going to get a lot later because we still have quite a bit more to cover. So it's not that I don't want the questions, I know there's some people have places to go and things to do, and for some reason they think a nice day like this there's something better to do than to listen to attorneys talk, okay?
Supplemental inventory, you find something else, you let us know about it, we let the probate court know, and we carry on from there. And then the personal property, that's the tricky piece. Sometimes you might want to actually hire an estate appraiser to come in, if depending on the family situation. Family members are pretty much going to agree who's getting what, but you've got a list of what it is and who it went to, then at least you've made an effort at accounting for those things. And the value's never what you think it is. So yes, and then inventorying bank accounts, brokerage accounts. We want to know how it was titled. Is it jointly? Is it with rights of survivorship? Is it individually? Is it in a trust? What the date of death value is? What income is accruing? What's going out of it if it's a checking account? Are there any loans outstanding that need to be paid off? We need to know about creditors. Is there a safe deposit box? Is there anything of value in there besides a rubber band and maybe a penny? And
That's a real case.
yeah, that was months and months and months to find out about the rubber band and the penny. And some carbon copies of checks from 2002. And then brokerage account, same thing. And every bank, every brokerage account will have their forms. This is what we need you to fill out to decide, how we're going to pay this out to you, so you can start consolidating those assets into the trust or the estate. IRA is the same thing. You'd want to know who the beneficiaries are. You pretty much should know who the owner is if you've got any of those statements. And then what the value was on the date of death. That's all going to tie into the estate tax return that everybody needs to file in Connecticut. And then claim forms so that whoever your beneficiary is gets their share.
And
Pensions, there may be back benefits, there may be a death benefit, so we'll contact pension companies as well and also let them know, please stop the direct deposit so that we can close this account out and not worry about you taking it back out.
And just because you get a check from your IRA or your employer's 401k plan, don't cash it, call us. It may not be the best thing to do to take that check, and that's always a hard thing to not do. How many of you want to not cash a check that comes in the mail? Okay? Now, this slide's actually getting a little old. Retirement plans are one of the most complicated assets to plan for a number of reasons, primarily tax issues. In 2003, we've got some major changes in the regulations. I'm going to change this slide because nobody cares that long. But we have to make sure, if you did planning a long time ago, you haven't revisited your beneficiary designations for your qualified plans, you really should. And we're going to give you an opportunity to find out how to learn more about this later, okay?
The beneficiary designations is a lot of families, it's the chink in the armor. They've planned everything else great, and then, oh, we forgot that we haven't touched that beneficiary designation in 4 years, and we forgot who's named. And sometimes it can cause a whole bunch of problems after the fact.
We had a couple of questions at the break, and I'm going to throw this out there too as a reminder to all of us. I mean, we do an annual asset verification, and I'm not sure that we shouldn't be requesting some kind of beneficiary verifications as well. For those of you who just talked to me about, possibly want to make some changes to plans and make sure things work, we can help you stay on top of that if that's something that you're interested in. So, and then for any insurance claims as well, you'd want who's it supposed to be paid to, how much is it worth? We can request the form that would be evidence of those items, and help you get those claim forms in so you can get them back out and turn that around as quickly as possible as well. All assets need to be valued as of date of death. And that means anything you had any kind of interest in, even if it had a beneficiary designation passed outside, you never touched it, you put that paperwork aside. Automobiles will use Kelley Blue Book. Difficult to value, could be the artwork, could be the jewelry, could be business interests, and we're going to, I can't say require, but we're going to recommend that you use qualified appraisers for those things. Real estate as well, you're going to want, you're not necessarily going to want to rely on the assessed value from your town from 8 years ago. And then for those pricey personal items, get an expert in who knows what they're talking about. The cost is not as much as you think, and the value of having it done and done right and not going back and forth with the probate court, for example, 3 times, or with any particular beneficiary about how assets were divided, priceless.
Or not being able to prove what it was really worth when you got it and you sell it, and now you have to pay tax on the full check. We will help you, because Rebecca says if you have a business interest, we'll recommend. If you don't follow her advice, you'll sign a letter saying, I was told and I chose to ignore it. It's that important.
You don't want to be arguing about capital gains so far down the line that there's no record available of where you started. IRS doesn't like that. So making sure you have cash needed to maintain any real estate that you might have. If you've got an ongoing business operation, we'll help you with some of the budgeting to say, okay, what was coming in, what was going out. That's where those bank statements are really useful. Most people are not writing checks from several accounts. You can see what household expenses look like, and we'll do a little bit of forensics on those accounts as well to say, hey, it looks like insurance premiums were being paid out of here. What does that cover? Those kinds of things. We'll help you obtain the tax ID numbers that you need for each separate legal entity that may have been created at this point in time. Your social security number is not sufficient anymore to identify a lot of your assets. Help you change or retitle the account so that the executor or trustee has signing authority to do what needs to be done. And then making sure that we've got, if there are liquidity issues, we can talk to you about. The money's only going to go so far, but we can help you plan, prioritize what needs to be taken care of and what's just more on the wish list. Send notice to creditors so that we have a centralized location. They'll send us notice of what their claims are. You don't always know how many credit cards mom and dad had. So this will help. There'll be a legal notice published as well as the ones that we know about. We'll send notices to. So we can start making sure that those things are getting taken care of and that your phone isn't ringing saying, how come this bill isn't paid? How come this bill isn't paid? And then if it's something that I know they had AT&T and this is their phone bill, we'll advise you to pay it. If it's something you've never heard of, we're going to look a little bit deeper on that and then take care of what needs to be taken care of.
Another part of our role is as fiduciary, if all of a sudden you're confronted with a unexpectedly large pile of bills and claims, we will discuss with you when things should be paid and in what order, because almost like, not nearly as complicated as the bankruptcy code, but there is a sort of a mini bankruptcy code of how creditors are satisfied. And the gentleman's question about the funerals, for example, it's in the statute at the top of the list. So we need to make sure that these folks need to be satisfied before these folks, who need to be satisfied before these folks. And some of these folks may, in the end, not get satisfied at all if the estate's insolvent. So we'll work with you about how to handle that process correctly.
And luckily, we're second. So call. Here we go. I'm sorry. So we've got the probate court fees that correspond to what that value of your gross estate is. And when I say gross estate, I mean everything you had any kind of ownership interest in. This is not a tax. And this is how it's calculated. It could be anywhere between the $25 minimum fee up to the $12,500.
So it's cheap. But it's
For the
not a
pleasure of
tax.
dealing with the probate
and
court.
this has no bearing whatsoever to how much or as little of the probate court resources are involved in this process.
And if you have any reason to have an ancillary probate in Connecticut, you have real estate here, this is not where you live, you're going to have to prove that you do not live in Connecticut.
So in other words, like the conversation I had with a client who was in yesterday, he likes to golf in Florida, and they own a place down there, and he thought he'd just become a Florida resident because he hears there's no state income tax and there's no state estate tax. And it is much more difficult to really become a resident of another state if you're still spending time here, okay? And the way the state gets you is if you have any real property, because everybody wants to to know, how do they catch me? Okay, I don't know. But one of the ways I will tell you that they might catch you is if you own real estate here, you have to file this Form C3, which is, what, 4 pages?
It's about
Haven't-
right. I think that-
Somebody told me 3, but
It's 3, it's a number of pages. Anyway, you go down, and it's going to ask you questions you would never guess, like, do you have a country club in Connecticut? Okay? Little things like that.
You know, fraternal orders, all that stuff.
So
Elks Club.
if you want to be a resident of another state, we can help you plan on how to do that and make sure you really are. But if you haven't, this catches you up.
And I think we've talked about the estate tax return, 2 different kinds. If you're under the $2 million, it is filed only with the probate court. I'm going to attach copies of everything that I'm including on there so they can verify everything. Pretty much what, in our experience, they'll say, great, fine, we've got it all. We may have a question, they'll call. Otherwise, you know that you've done it right when you get the invoice in the mail. Above $2 million, you're filing a full CT 706 with the Department of Revenue.
And one of the reasons it's so important to get this done right, because I'm going to tell you quite frankly, when they first did this, there was no penalty in the statute for not. And it only took the legislature like 3 years to figure it out, that a requirement without a penalty might get ignored. Okay? And now, if you don't pay the fees, they accrue at 6% interest until they finally catch up with somebody who got the assets. And by the way, if those Indians who got $24 from Manhattan, if they got 6% interest compounded, they'd own the whole country. Okay?
Again, this is how we would calculate what that estate tax would be above and beyond the probate court fees, and it starts at 0, 7.2%, all the way up to $748,200, and 12% of the excess over $10.1 million.
And we're going to talk in a couple of minutes about why sometimes you may want to pay that lower estate tax rate as opposed to avoid it. And I know that's like some of you are curling up and saying he's crazy, but we'll help you understand that in a minute. The federal estate tax, it's now indexed for inflation. You have to have an estate of more than $5.3 million before there's any estate tax at the federal level. According to the IRS, it applies only to about 0.33% of the people in the country. You've heard of the 1%? Well, this applies to the 0.33%, the 1/3 of 1%ers, okay? Others say it's only about 15.15%. Doesn't apply to many people, and it's going to index every year. The rate is at 40%. Above that, you've got that gift tax exemption we've already talked about, okay? But there's a new thing in the law that says that each spouse has this $5.3 million, and if you don't use it, so let's say your estate's only $5 million, that extra $340,000 can be passed on to your surviving spouse. Or if your estate's only $1 million, the $4 million, what? 300,000, can't remember all the numbers. Or if you don't use any of it all because you leave it all to your surviving spouse, you can leave the full $5.3 million exemption to your surviving spouse, but the catch is what?
You have to file a full 706 income estate tax return to claim it. And you need to do it within 9 months of the date of death.
That's the
Or
first
extent.
to die, right?
First to
Yeah,
die.
the second
Yeah.
one doesn't have a
Right,
surviving
and so
spouse.
that's filing, and that's filing it in a circumstance when you otherwise would not need to.
Right.
So that's why we, need to have the conversation about why you might want to go ahead and do this.
So the benefit in Connecticut is you're pretty much pulling together a lot of that information anyway for your estate tax return for Connecticut. We will do the federal. If it's something that we recommend and there's any likelihood that you would need that portability, we'll talk to you about it. And again, if you say, no, I'd really rather not, we'll say, okay, here's another letter that you can say, I was advised, and I chose not to.
Okay. This whole notion of Clayton election, the rules have changed dramatically. When we first started doing this, the real boogeyman that we often got people in the office, even though I never believed it was the best reason for doing planning, was they were afraid that they were going to have to pay estate taxes. When I started doing this, the exemption was $60,000. I think when we went to 600,000 in the early 90s, or maybe late 80s, okay? And so there are lots of folks, you know, your house by itself would put you over the limit, okay? Well, now, I just showed you what the state estate tax rates are. They cap at 12%. What are income tax rates? Fred? What are marginal income tax rates? 35 plus 3.8%? Plus 3.8%? Capital gains anywhere from 0 to 20? 25% plus state tax. Income tax planning has become a much bigger part of estate planning than it ever was, and so we use this thing called the Clayton election that lets us, after the first spouse has died, decide whether we're more concerned about estate taxes or income taxes or something in between the two. We could do an hour on that, but I won't.